This is case number 25000763AV, Gratiot Square LLC versus Liquor Basket Gratiot LLC.
Council appearances for the record.
Good morning, Your Honor. Michael Stevenson, appearing on behalf of Gratiot Square.
Good morning, Your Honor. Attorney Elizabeth Ellison, P82098, appearing on behalf of Liquor Basket Gratiot.
Okay, now I know we adjourned this. Refresh my memory. Why?
My understanding, Your Honor, you had denied my motion to dismiss and you adjourned it to hear his leave for appeal. Application for leave. Mr. Stevenson can correct me if I'm wrong.
No, I believe that's correct, Your Honor. And you also gave Ms. Ellison an opportunity to file a response to the application for leave to appeal.
Correct.
And Ms. Ellison, did you?
Your Honor, my response was late. My response was late, but I did just rest on my arguments that I made in my motion to dismiss.
Mr. Stevenson, relative to your request for your leave for appeal, let's hear them.
Well, Your Honor, I indicated in my argument before that I believe the appeal was timely because it was filed within 7 days of my receiving notice that the order was entered. We had discussed at that time that the court was closed during the period between Christmas of 2024 and New Year's of 2025. The court indicated at that time that the court rules required that the claim of appeal be filed within 10 days of the entry of the order, not the service of the order. And I indicated to the court, but there was no way for me to know about the entry because it wasn't entered on the register of actions. I think you indicated at the time that even though that was the case, you weren't going to dismiss the appeal. I indicated also in my argument in the application for leave to appeal that I filed at the same time as I filed the response to the motion to dismiss, that the court rules clearly give the court jurisdiction over granting leave to appeal, even with regard to cases where the claim of appeal was not filed timely. And while I disagree that the claim of appeal was not filed timely, I think that this is a case that still warrants the grant of a leave to appeal because there are meritorious claims here. And the court rules that I cited to in my brief in response to the motion to dismiss, as well as the case law that I cited, indicates that the court has the power to grant leave to appeal, notwithstanding the claim of appeal being filed untimely. The defendant's argument essentially to the court before was that the case would have to be dismissed, and then I would have to file an application to appeal, which to me seems like all it does is create more time and effort for the court as well as the parties. I mean, the issue has been joined already. The court rule specifically says that you have the right to grant leave to appeal. What the case indicates is that where you don't have jurisdiction over an untimely appeal is to hear the appeal as a claim of right. So if the court decides that it doesn't have jurisdiction over the appeal to hear it as a claim of right, it still has jurisdiction to decide whether it's going to grant leave to appeal in this case. So while I assert that we have a claim of right to appeal, if the court decides that we don't have a claim of right to appeal, the court still has the jurisdiction to determine whether a grant of leave to appeal should be given in this case. And I would argue that there are significant issues of material fact. There is a basis their meritorious arguments that the district court erred and that the court should grant leave to appeal. In addition, I would say that even though I think the defendant's attorney also argued that with regard to the jurisdictional issue regarding claims of appeal by right, the court can't take into account the lack of prejudice to the other party. That may be true with regard to a claim of appeal by right, but it's not true with regard to a claim of appeal by leave granted. And I would indicate to the court that the court has all the authority necessary to grant leave to appeal in this case. I would urge the court to grant leave to appeal in this case if the court decides, as I think the court did previously, that this is not a claim of appeal by right. And as I indicated in my papers, I think that there are various issues for appeal that this court should decide, and it shouldn't dismiss this case.
Ms. Ellison, I know you relied on your prior pleadings. Is there anything else you need to add at this junction?
Your Honor, the case was originally applied or filed as an appeal by right. I think by allowing it to be transferred to an appeal because they missed the timeline by right to then say, okay, we'll just convert it to a leave for appeal. I think it's setting a dangerous precedent that if you don't meet the deadline, it's okay, the court will correct it on the back end. I'm not saying he's not within his time limit for filing his leave for appeal, because he's absolutely within the 6-month timeline. It's the fact and the manner of how it's proceeding. I think there's a reason that there's a precedence for 10 days from the date of the appeal. You're basically saying, okay, if you miss that 10 days and we argue that the court has no jurisdiction, that you can then transfer it to a different kind of appeal. Like he said, my argument is not that he can't file it. It's the process and the manner in which it's being filed. I still stand on the fact that the court has no jurisdiction since it was filed as an appeal by right initially, and that when the court has no jurisdiction, they can only dismiss the matter. But as opposing did say, we have already really discussed this at the last hearing, and you did indicate that you were not dismissing. And you would set a new timeline for a briefing. So.
Right. And as you know, as has been indicated, this was one of those cases that has a unique scenario in that, as Mr. Stevenson has indicated, this order was issued during the holidays, and there was, in terms of him being able to respond within it, and he responded as soon as he practically could have. But then additionally, he is entitled to leave to file an appeal by leave. And in looking at it, he is within his right to do that. And it would be an exercise in futility. It was a misuse of judicial resources. If we said, okay, no, you're not going to file it, but come back again. It's just for the economies of justice that the court will allow the leave to be granted. There's no prejudice to the appellee in this situation, and the court is going to allow this to proceed. So the court is going to deny the motion to dismiss, but the court is going to grant the appellant's request for leave to file an appeal. The court also notes that Mr. Stevenson did raise meritorious defenses, which should be pursued by the court. So I need an order indicating that the motion to dismiss the appeal is denied. However, the court granted leave to appeal by the appellant based upon what the court has previously articulated on the record. So what I think the best thing to do is, Ms. Ellison, you present your order denying the motion to dismiss, and Mr. Stevenson, you present an order to the court granting the leave to appeal. And once you file your appellant brief and get the court a hard copy, my law clerk will issue a scheduling order.
Your Honor, just for the record, I've already filed the appellate brief.
Let me make sure. Hold on.
Yeah.
Please submit another hard copy because I don't know because of
Sure.
the instances that were going on. I don't know because that was back in March.
Yes, we filed it back then and we submitted a hard copy to the court, but we'll be happy to submit another hard copy to the court.
Right, please do so. And like I said, file both of your respective orders.
Sure.
And I just want to make sure that my law clerk, because like I said, that was back in March. And
Sure.
I do see. Okay, so that was received. It was logged into Odyssey on March 26th, and we received your hard copy on April the 2nd. So just to ensure that we have a proper timeline and things can flow directly from this, please, Mr. Stevenson, have someone bring over another hard copy, and then the
Sure.
court will issue a scheduling order.
Will do, Your Honor.
Okay, thank you both.
Thank
Thank
you.
you.
Thank you, Mr. Stevenson.
Thank you, Ms. Allison.